let's get into the life cycle of a private practice. Certainly, we're going to try and cover off quite a few topics as we work our way through this evening. It's quite a broad topic area that we're going to look at. As you can imagine, the life cycle of a private practice is a very long cycle, hopefully for all of you. So we've got a few things to cover off, and we'll definitely be looking to do a very broad overview of those issues to keep in mind, as well as try and diving into a couple of things that are particularly important for you to all be mindful of. All right, so look, a bit about me. You're all probably wondering, why is there an insurance lawyer working at Avant talking to us? I'm not an insurance lawyer. Avant, for those of you that don't know, launched a commercial law firm essentially in June, July last year. So it's a full service offering, and as a result, I'm working at Avant Law and assisting with all things commercial for all of you as part of your member benefits. It is a fee for service, but you do get a 10% discount on all of your legal fees with us as a reward, and certainly a thank you for having your policies with our parent company. In terms of a very general disclaimer, we lawyers like our disclaimers, but tonight it is the case that this is all intended to be a very general overview. Every practice is different. Every person's circumstances are a little bit different. If you do want to take up the opportunity after tonight to have a conversation with myself or one of the other team here at Avant Law, please do take up that opportunity. Always happy to talk through any plans or prospects with anyone, and that way we can make sure that we're tailoring the advice and the conversations with you as a nice benefit. I say we've got quite a few things to get through tonight, so we are going to try and burn through it as quickly as possible. I appreciate that it's a Tuesday evening for everyone, so they're probably keen to get on with relaxing after a hard day's work, or hopefully not too many of you are still at your respective practices. As you can see, we've got a few things to cover off, from all things starting a practice, growing, and then succession as well. So let's get into it. In terms of starting a practice, this can often be the greatest challenge for a lot of people to overcome before they can even think about going into private practice themselves, and certainly can put off quite a few people from going into private practice because it can be a bit too daunting. What we always say to any client that comes to us that's thinking about going into private practice and owning their own business is that really, whatever practice structure you choose from the start, we want to try and make sure it's the right structure for you throughout your entire career, because there can be implications for restructuring in the future. So we like to have a bit of a conversation and a discussion with all of our clients of essentially, where are you now? Where are you hoping to be in 5 years, 10 years, and 20 years? And hopefully in 20 years, the answer is kicking back on the beach, drinking mojitos. But if that's not the case, we want to make sure that we're setting you up with the right opportunities and the right structure to hopefully make your business as successful as humanly possible. If you're going to be a sole practitioner, it's essentially what most people are when they're working in private practice and just dipping their toe in maybe a day or two. You'll have your ABN, you'll have your own insurance policies, you probably won't have much else. You might have your own staff potentially if you're a very small practice. A lot of very specialists may just opt for a sole practitioner style business if they're not planning to have growth and they're just looking to work for themselves or as themselves. You then progress to companies. Now, partnerships used to be a fairly common structure, and you've probably noticed that it's not on there because we're not seeing partnerships very often, and in their place, we're seeing a lot more companies for medical practices. And this is because it just gives you a lot more flexibility and a lot more protection moving forward, particularly when it comes to how you're going to deal with costs and how you're going to deal with profits. What we see a lot of the time is that doctors will be working different hours, different days. Some people may be working 3 times as much as other doctor owners. So we want to make sure that potentially we have discussions with everyone at a very early stage of, is everyone going to equally share in the revenue of the practice? Or will there be some special profit distributions to take into account the fact that some people may be working more than others and generating more revenue? At the end of the day, you can also do quite exciting things. Well, I think they're exciting, but I am a lawyer. But quite exciting things with profit splitting and incentivizing your staff to retain them, which we'll get to in a few slides' time. One point that I want to touch on with company structures, and you can deal with it in other structures as well, but typically comes up here, is how do you deal with succession planning for death and TPD? No one likes to think about their own mortality, but it is one of those important things to cross off as part of the company process and setup. We've seen instances where people have passed away very quickly and suddenly, and the practice is left with a clause that says they have to pay out the fair market value for that person's interest. Now, if it's a successful practice, the business might not have $1 million or $2 million or however much just sitting in cash reserves waiting to buy out a partner. So you can have potentially some insurance policies or other documents in place to actually allow you to capture and pay for those interests without actually damaging the cash flow of the practice or having the other owners have to stump up the cash to pay out that person with no real notice. There's a lot of ways that we can structure these things, particularly companies. So we always recommend when anyone's looking at starting a practice that we essentially have a roundtable conference. You sit down with your lawyers, your accountants, and all of the owners in the business. And we have a nice little roundtable discussion of what you're hoping to achieve. And more importantly, if you're planning to have doors open on the 1st of July this year, let's figure out all of the steps that you need to go through to actually get yourself in a position to have the doors open on 1 July and make sure that everything's ready to go. It does take a little bit of time to get all of the agreements and everything in order, so try not to leave it too late. Certainly, if you feel like you've left it too late, it's always easier to have the discussion than to not do anything. So, do have that discussion with your accountants and your lawyers. Trusts are a bit of a difficult aspect because there's not as much flexibility in trusts as there is in other aspects. We want to make sure that we've got some flexibility for yourself, and usually as a result, you end up with hybrid trusts. When I'm talking about flexibility, a trust or a unit trust or a fixed unit trust is something that a lot of practices will have. And if you've got 3 owners, all that will mean is that people are receiving a 1/3 dividend directly from themselves rather than potentially having that flexibility I mentioned for a company where people have shares that can have that flexible aspect in it. So as a result, you do need a hybrid trust. But look, ultimately, at the end of the day, there's so many options, and we really do recommend that you talk it through with your advisors so that you can make sure you're doing the right thing. And then we get to, after you've dealt with all the boring structural things and structural messages, then you get into all of the other important things. And this is why I say it's important that you sit down with your advisors early on in the piece to make sure that everyone knows what you need to get done in terms of box ticking to actually progress everything nicely and make sure that you've got all of your ducks in a row for that doors open. Employment agreements are one of those non-negotiables when we are talking to practices that are going to have employees. Really looking at employment agreements and service agreements in a medical centre as being 2 very fundamental documents. Employment agreements are incredibly important, particularly because in Australia, as you can see, there's a lot of heavy regulation around employee entitlements and what you should be doing with your employees and what you should not be doing with your employees. So making sure that you have really clear employment agreements, whether it be full-time, part-time, or casual with your staff, so that you can make sure that you're not only having a nice, clear arrangement with each of them, but you're protecting yourself as much as possible. Particularly, hopefully you've all been watching our employment teams with Stephen Schoninger, employment law updates. Just so you know, there is one actually tomorrow night, which I've got some detail on for you at the end of this presentation to talk about how to handle employment complaints and other issues. So that's a very common issue that we see in medical practices. So hopefully you can take some messages away from that. But certainly employees have, hopefully when you do get to your employment agreements, you can see that there's a lot of detail in there, and it's all in there necessarily to protect yourselves. Service and facility agreements, everyone is probably more than sick of hearing me talk about service and facility agreements and every other man and their dog talking about service and facility agreements. But for any of you that haven't already heard my rants and spiels about all of these things, we'll very quickly cover them off because they are very important. The most important thing, particularly from what we've learnt about the Thomas and Nas appeal, which came down not that long ago, in the last week, week before last, it's all going very quickly, is the fact that the flow of funds is going to be incredibly important for determining whether a relevant contract exists for payroll tax purposes. Now, that sounds like a very legal heavy spiel, I accept. So really what we're talking about is if the practice is receiving money on behalf of the doctor, which was very commonplace, and then paying that money from a clearing account or whatever other account it may be into the doctor's account after deducting the service fee, there is a very strong argument that payroll tax will be assessed because of the fact that the practice is paying money to the doctors. So what we've been looking at and talking with a lot of advisors about is potentially shifting it such that if you want to continue to have a service and facility agreement, you need to make sure that you're directing payment direct from a patient to the doctor, and that the practice then invoices the doctor for its service fee. That's a fundamental core matter that needs to be happening. I know a lot of people have been looking at a lot of options in relation to this, and certainly an extreme would be the fact that you have tenant doctors, and they're very clearly just tenant doctors, and there's no services being provided to those doctors. They're just hiring a room from you. We haven't looked into that any more than essentially a very cursory view, because we don't think that medical practices are really going to have much of a business if they follow that mechanism. And you really won't have much of a business if you follow that mechanism, as well as having accreditation and registration issues. So we don't think that's a workable solution. You then have the potential risk where the Revenue Office will say that the practice is essentially facilitating a third-party payment from Medicare or the patient to the doctors. I think that's a fairly hard argument, but look, it is a ever-present potential issue, but it's a third-party payment, and I think that's a very difficult argument for the Revenue Office to try and put forward, that it's somehow on behalf of the practice. Once you've looked at the flow of funds, there's all these other issues that you then need to consider in terms of rostering, work hours, non-competes, the fact that the practice doesn't really have an ownership over the patient records. It's more so the doctor that has an interest. And so making sure that it's clear that the doctor assigns or licenses rights for the practice to retain a copy of those records is really important. And so, look, ultimately, at the end of the day, service agreements have changed quite significantly over the last few months even. It's important to have a really good dialogue with your advisors, and we're talking quite often with our clients to make sure that they're across all of these changes with payroll tax and service agreements to make sure you've got the best thing possible. But as I say, it is one of those non-negotiables. You really do need to have it when you are setting up a private practice, and it's one of those things that should be reviewed annually, even if it's a very brief discussion of, is our service agreement still current? And hopefully the answer can be yes. We've got a very good question, which is, how is it different from a real estate agent collecting rent from a tenant and then passing it on to the landlord minus the service fee? I think what people are probably starting to clue in on is the fact that this has far broader ramifications for people in Australia than just medical practices. We've got brokers in New South Wales that are starting to get hit for payroll tax implications. There's even potential implications for law firms that might have special counsel who are technically receiving fees that are paid direct to the law firm. The law firm's then paying money to those special counsel less a fee that they take for providing administrative services. It's not just medical practices that are getting hit with this. It does have very broad reaching implications for a lot of other people. So whilst it might feel as though you're all the only people getting affected by this, you do have the added benefit of the AMA and the College of GPs and various other colleges advocating very hard to try and get these circumstances as improved as possible. And because of the work that you do, You also have the added benefit of the government needs to make sure that you're all relatively happy and then they're not annoying you too much. So I think you're in a fairly good position, particularly if anyone is in Queensland. We know that they're not going to go back past the 21 fin year. The amnesty, there's some further information about that now as well in Queensland. So there's nothing on that yet in other states and territories, but I suspect hopefully that will come. Ultimately, it's going to be a bit of up in the air as New South Wales goes through its change in government as well. So watch this space. There'll be more from us on the payroll tax, I suspect, in the next month or two. And then independent contractor agreements are a little bit more complicated than a service agreement or an employment agreement, purely because they're that one step closer to an employment arrangement than what a service agreement is. Because under an independent contractor agreement, really the practice is engaging that independent contractor to provide specific services for them. As you can see, there's a lot of complication with independent contractors, and it's one of those instances where you really need to talk through with your lawyers, with us, about how you intend to use that contractor arrangement. And it really should be on a fairly short-term basis, just to avoid any potential implications with employment or otherwise. You don't need to account for leave or other entitlements that an employee would ordinarily have under a true independent contractor agreement, but there may be some superannuation entitlements that can arise. We don't see too many independent contractor agreements these days in medical practices because most people are either employed, like your registrars and your nursing staff, or you'll have a service agreement with them. But it's still an important agreement to be aware of because there's a lot of risk, and probably more risk in terms of that employee or that contractor arrangement being very murky and being very difficult to differentiate. Intellectual property and privacy are often put on the back burner when someone's setting up a private practice, because a lot of people will go, well, I don't really need to worry about a trademark. I don't really need to worry about domain names or other things because they're not really relevant and they're not going to affect my bottom line. One thing I would say, and you don't have to use your lawyer for this, you can go onto IP Australia and do a free trademark search. If you do that free trademark search over your business name that you're planning to have, you'll be able to see if there's anyone else that's currently conducting that medical practice name. The unfortunate thing about medical practices is that a lot of them are very descriptive and prescriptive about what you do and where you do it. Brisbane Specialist Centre, Sydney Specialist Centre, orthopedics group, etc., even GPs are very descriptive of Brisbane General Practice Centre or whatever it may be. So when you're thinking about your brand and what you're planning to do, you need to be very mindful of the fact that you potentially are doing yourself out of the ability to grow and grow your footprint. If your only intention is to just have a single site location, and you never intend to open up a group of practices across a set area or across the country, then it may not be as much of an important thing for you to register your trademark. But certainly, if you come up with quite a funky logo or brand name or whatever it may be, maybe have a bit of a chat with us about what that trademark may look like and make sure that you're protected. While you can, with trademarks, use that little R logo only when you've registered the trademark, it gives you that benefit of if someone else comes along trying to use your goodwill and pass themselves off as a related entity of yours, then that's even easier for them to do if you don't have a registered trademark. The best business in the world that's run by teenagers and has a very good trademark is the most known trademark in the world, which is McDonald's. They've got fantastic brand recognition. It doesn't matter where they are, you know exactly who they are. There's a lot of medical practices out there that have very good trademarks as well, and as a result have the ability to have multi-site locations that people recognize and associate goodwill with. So it is an important consideration. Copyright, A lot of people have come to me saying, I can't figure out how to register for my copyright. I've gone onto the website, I've paid $50, and I've got the C. Is this okay? That you can't register copyright in Australia. It's essentially inherent under the Copyright Act. So a trademark is a registration to protect your brand and your logo. So the Avant logo would be registered with IP Australia as a protected trademark. Various other brands do have that registration as well, and you have the ability to use the little R symbol in conjunction with it. Copyright is essentially over the actual words that you're putting out there. So if you're writing reports, if you're producing content, or you're producing new means or ways of doing something or a procedure, you may have copyright over that. You also might need to consider patents for how you're dealing with something as well. But patents certainly are fairly rare in private practice, so I haven't got anything up there about that. You then get onto domain names. Now, this seems like a very weird thing for a lawyer to be talking about, but making sure that if you are going to have a practice, you secure the website, website domain, potentially your Instagram, Facebook, LinkedIn, etc., purely because you'd want to make sure that you capture all of those things before you go live so that a competitor doesn't take them from you. There are also businesses out there that register them and then sell them back to people that don't register certain domains in time. So just be very mindful of that when you are looking to register a brand. Licensing is one thing that does come up, particularly for those groups that are looking to have quite a large footprint. And particularly where you want to have the ability to essentially sell your brand to other people so that they can trade under your name and use your goodwill. Less common, but certainly for those people that are looking to have a very large, multi-state, multi-location practice, that might be something worth thinking about. Privacy is one issue that a lot of people are panicking about, payroll tax, and it's sitting away in the corner, potentially becoming a bit more of a problem than people realize. Certainly the Latitude Financial issue this week has highlighted that it's still very much a live issue. There's at least a few medical practices every day that are getting attacks or attempted attacks from hackers trying to get in. So make sure that you do have on your website when you are starting your brand, or if you're looking to just have a review of your practice or you're looking to grow your practice, make sure you have really clear website terms of use, privacy policies, and disclaimers. Unfortunately, most people's first contact with a practice these days is just on a website, and you'll have to put in the details of name, address, date of birth, potentially Medicare number, email, and so on and so forth. Now that's gold to hackers, and unfortunately medical practices often take the least amount of security for their very sensitive information. So making sure you're very clear with how you're going to use it, why you're collecting it, and potentially how you're storing it are really important things to tell the consumer at day dot or at that initial consult. So making sure you have those terms is incredibly important. And of course, make sure you comply with the Australian privacy principles. There are mandatory data breach obligations if someone does hack you, or if you potentially have an incident that is reportable under the Privacy Act. There's quite a few privacy principles, and the government is looking to update everything, particularly following Medibank and Optus. It's a very brief snapshot of some important considerations for starting a private practice. As you can appreciate, there's quite a lot to unpack there, which is why, as I say, it's very important that you sit down with your advisors at the very start, both accounting and legal, to really plan out what you need to do. We can then put you in touch with the right people to talk about from a property perspective, from a practice management perspective, and other things, just to make your lives as easy as possible. It can be very overwhelming when you are looking to start a private practice when you sit down. I can assure you I've done it many times, and if you take the opportunity to plan it out, it's a far easier endeavor than trying to blindly bash your way through and just figure things out as and when they arise. When you come to growing a private practice, and particularly succession planning, failing to plan is just planning to fail. So no one hopefully is starting out in private practice with a view to just keep working in private practice till the day they die. Certainly, I don't want that for anyone. I'd like you all to be able to enjoy your hard work as much as possible after a very long and very worthwhile career. So really what we want to make sure is that we are starting with the end in mind and putting yourselves in a position such that you can build this asset, which a private practice should be an asset, and make sure that you're getting the reward for all of the time and hours and money that you're actually putting into this endeavor. Succession planning is essentially planning for how you want to exit the business in the future. So really we're thinking about who are you going to be selling to, what are you actually selling, when are you wanting to sell it, and why, where, and how. How is often one of the important things that are often overlooked, because people go, I'll build the asset, I'll build the practice, and then I'll sell it in the future. Particularly at the moment with payroll tax implications and potential liabilities, a lot of people that we're talking to looking to buy practices are looking to buy the assets, not to buy the shares or the units in a trust from the people that own it. And the reason for doing that is because you can essentially carve out the liability for the business if you don't take the shares or the units in the holding company, and you just buy the assets from it. So a lot of people are looking to do it that way, but certainly that's when selling to a third party. If you're looking to potentially surround yourself with a really good team of associate doctors who potentially you might sell your practice to in the future, those people would have to potentially buy your shares or your units in the company, and you may do that in a staggered approach so that they're getting a bit of an incentive for the longer they work and how they work, but you're retaining as much control as possible. There are a lot of ways to do it, and certainly I encourage everyone to, as I say, you're going to probably get the theme, but sit down with your accountants and your lawyers, and just make sure you talk it through with everyone at the same time. When you're thinking about growing your private practice, it's important to think about why you're doing it as well. Ultimately, it doesn't matter which reason you're choosing to do it for, whether it's maximizing the value, whether you're altruistic, or if you're just looking to make hay while the sun shines. Really, it's a case of it's a fundamental aspect of your business to make sure that you've got a really good plan for how your business is going to grow, how you're going to sell it potentially in the future. Because really, at the end of the day, if you've got a really solid position on how to sell your business in the future, you may find that you end up growing it even easier because all of those key criteria for people to latch onto, to invest in, and to keep them around are really nicely laid out for them already. So the investment on the front end of a really clear shareholders agreement or unit holders agreement to deal with your company or your trust can actually make a significant advantage for you later on in the track. Ultimately, it's important to think about, and the time investment can be very helpful. One of the greatest issues that I deal with on a daily basis is how do you actually keep doctors working with your practice? Certainly, if anyone thought that they were alone in trying to incentivize people to come work with them or how to retain people that are engaging them, you're not alone. I know that probably doesn't make you feel too much better knowing you're not alone, but there are a lot of ways that you can try and deal with these issues now, that we certainly, these are just two options. I've seen an array of different things in between, so there's a lot of ways to skin the cat. One of the most common ways we see for trying to incentivize people to come on, because certainly historically a few years ago we would have seen payments from practices to doctors to come out to their practice to work there. We'll guarantee your first 6 months income. We'll pay you all this money to move out and to come to our practice as an incentive to get you to come and to stay. Because you're paying them money, if you're engaging with them under a service agreement, you're potentially shooting yourself in the foot and starting the relationship all off on the wrong foot, because you're paying them money. And hopefully you all remember me saying a few slides ago that the payment of fees from one to another is one of the greatest indicators of a relevant contract for payroll tax purposes. So That's not a great way to start off. How do you then incentivize them if you can't pay them any money? We've seen instances where people have gone, rather than a 35, 30, 25 service fee, which is probably something you'd ordinarily see for an established doctor, having an instance of a zero service fee for the revenue up to $5,000. Everything $5,000 over to the next threshold is potentially 10%, then 20, and then 30, and staggering it relative to the revenue that the doctor's generating rather than to a time period is always a much better way to do it. Certainly, it might take them on average 3 months to get to where you think they're going to get to. But if you have a bumper start and they get to the billing threshold you wanted them to in the first month, they've then got potentially 2 months of very generous service fees and you're losing even more money. So always tie the service incentive percentage to the monetary threshold, not to a time period. In terms of incentivizing doctors to stay and how to retain them, one of the most effective ways we've seen is not only the ratcheted service fee, but also offering share or unit incentives. Now, I want to be very clear, I'm not talking about giving doctors equity stake in your business where they potentially get a seat at the table from the very go and have a say in how you operate and get a share of all of the practice entitlements. What we have seen and has seen as quite an effective way of incentivizing them to stay is if you've got Dr. Smith is generating 30% of the total practice revenue and is just really working very hard, and you're starting to think, they know that they're making a lot of money, they know they're paying us a lot of money, how do we get them to stay? You might offer Dr. Smith a A-class share in your company. Now, that A-class would be a special class share, not an ordinary share. And because it's a special class share, you can essentially say however you want that share to be and whatever you want it to be entitling Dr. Smith to. So what we've seen is that special A-class share essentially saying you don't get any right to vote at the company level, but what you do get a right to is to receive a dividend at the end of the year that is entirely discretionary and is proportionate to the amount of fees that you generate for our entire business. And the easiest way to explain that is if I've got an A-class share and I generate 30% of the total revenue for the practice, after all said and done, after all the money's gone through and your net profit's calculated, if the net profit is $100,000, which hopefully it's more, but if it's $100,000, then you would potentially be able to say to me, look, Ben, thanks very much for your hard work. We want to give you a bonus this year. Here's a 30% entitlement. And that would go through at the shareholder level, so it won't trigger any payroll tax issues. But it's a way of incentivizing me to say, look, thanks very much for your hard work. Here's an incentive that you would probably receive if you ran your own business, but you don't have to do it. And we want to keep you working here. And look, that's something that we've refined with accountants over the few years to make it as effective as possible and to try and incentivize them to stay. And as I say, it can be a very useful way of doing it. If you have a trust, you can do it as well. You just need to have a discretionary trust. It's a little bit more complicated, but certainly achievable. Property is one of the greatest issues for practices because it's one of your largest overhead costs. You've got obviously your employments for your nurses and your admin staff, but then usually either first or very close second will be your rent. Now, if you can own your own practice location, hopefully in trust or SMSF or whatever it may be, you have a guaranteed tenant because you know that so long as you're your own landlord, you're going to have a good revenue stream going straight from your practice to your property holding entity. And this is one of the things that we've seen being quite successful for a lot of clients over the years in terms of helping to fund their retirement potentially. It's not to say that you have to buy the practice location that you're in. Certainly, if you don't currently own it, or if you're looking at a premises and the landlord might be elderly or whatever it may be, you might potentially look to have a provision in your lease when you are negotiating it that allows you a first right of refusal to buy it if the landlord decides to sell whilst you have a lease. Something food for thought to think about if you are looking to take a new lease. It doesn't hurt to ask for that first right of refusal, and certainly gives you an opportunity to become your own landlord if you aren't currently. If you have the ability to become your own landlord, and you do get the opportunity to buy your own practice, one thing that I want to make very clear is that you must have a lease between your practice entity and your property entity. You need to justify to the tax man why that money is going from one entity to another. And if you don't have a lease to easily do that, you potentially create some problems for yourself. The other benefit of having a lease between your practice entity and your property entity is that if you decide to sell your practice to potentially a third party or to other people within, you have a guaranteed tenant, you know what the lease is going to provide for, you know what the rent is going to be, and you've got very clear terms there that you can use to your advantage. So it's a very good way of trying to maintain these things and to have an added benefit that you can potentially bring to the table when you are setting up or growing a practice. In terms of how you're going to deal with it, potentially if you do grow and or sell, so as part of the succession planning, before you sell your practice, if you're wanting to retain the lease and the property, make sure you look at the lease before you sell. One thing that we've seen a few times is practices where they own the business, they own the property, they sell the business, but they forget to look at the lease and it's technically expired or it's only got a few months left. You really want to be trying to lock down the practice for as long as you possibly can to guarantee that rent coming in before you sell the business. So make sure you look at the term, make sure you look at the rent, make sure that the lease terms themselves are fairly fair, because at the end of the day, if you've got a clause in there that says the tenant doesn't have to pay rent if it decides not to because you were your tenant, that works really well while you're your own landlord and while your practice is the one paying the rent. But if someone else gets it, that may not be a very good thing for you. So you can have provisions in leases that essentially provide for the practice to not have to provide any bank guarantees or otherwise, so long as your specific entity is the tenant. And what that means is that if you sell the business in the future, the tenant will change and that clause will become no longer effective. So yeah, essentially future-proof the document without having to redo it every time or just before you potentially sell the practice. So just something to keep in mind. Also, if you are looking to sell the business to people that are coming up through the actual company, so these are your associate doctors that you might have incentivized with a A-class share early on in the piece. Important to think about whether they also want to potentially buy the property, particularly if they can afford it or how they may want to buy it. We've seen instances, as you can imagine, where very established practices where they own both the property and the business itself look to sell, and potentially it's vendor financed. So vendor finance is where the selling party essentially finances the buyer until they get the ability to pay it back. Make sure that if you are going to do that, you've got very clear finance arrangements in place to protect the selling as well as the buyer. Got a question of, is it routine in a lease to have the tenant to pay all outgoings, including rates, water and land tax? It does depend on who your landlord is and who your practice entity may be. Subject to how you're structured, you might have some restrictions on paying potentially body corporate fees, but otherwise rates, water, land tax usually will be in there. Land tax, what you want to ask for most of the time, and certainly I would encourage you to engage our property team to help you out with the negotiations, particularly when you do get a heads of agreement or a lease offer. But land tax should be calculated on a single holding basis. So what we see is a lot of landlords that own multiple locations may try and say that you've got to pay land tax for that landlord. If they own multiple sites, you're going to be paying land tax on the entire holding of that entire group rather than calculated on that single property. So your land tax bill is going to be a lot higher. Similarly with rates and water, you want to make sure that it's potentially metered. So metered to your specific premises. If it's not, then how else is it going to be calculated? You possibly may not know that. So again, it's an important one to just flag with your lawyers, or hopefully our property team, and make sure that you get them to review it. One thing I would say with leases, if you are looking to lease from someone else, i.e. you're not going to buy your own practice and lease to yourself, make sure that you never sign a lease offer or a heads of agreement for a lease without getting legal advice on it first. One of the greatest issues we have when negotiating leases for clients is the fact that you may agree to terms in a lease offer before we get the opportunity to check it. And it's very hard to then unwind that position and get you out of some of those terms you might have agreed early on in the piece. So it's a very easy process, but it's a good tick box to check off before you actually progress the lease any further. Important to think about how you're actually going to sell or purchase the business. These are just essentially some options, and I am mindful of time. I don't want to keep anyone too long if I can avoid it, but really it's a matter of how's it valued, who is doing the valuing, is it an arm's length transaction or otherwise, and is the property going to be included or not. In terms of before you actually sell, important to think about how you're going to sell. As I say, a lot of people are starting to, when sell to third parties, be forced to just sell the business assets rather than selling shares or units potentially in the business itself. It's important also to be mindful of the fact that subject to where you are, you might have obligations to notify your patients before you do sell, so that they know who to talk to, potentially if you are closing the practice or selling the practice in entirety, who they should be dealing with moving forward. While you would like to think that your business sale contract or whatever it may be deals with the fact that patients are taken from your entity to the new entity, you still may need to give notice to those patients to let them know that you're no longer going to be the one providing care and that they should be talking to insert party for all of their future needs. Regardless of who you sell to, anyone who is doing proper due diligence for the purchase from you, whether it's internal or external, should ask you for copies of all of your agreements with staff, suppliers, providers. Check your accounts, make sure you run it through with your accountants, actualize the accounts. Now, actualizing is essentially if you're running a practice and you're also paying for your family farm through the practice, and I had a discussion about this with someone only last week, make sure you pull all the farm assets and the farm costs out of the practice before you look to list it, and give yourself a few years' time to actually actualize the accounts. Essentially, take out all those additional costs that you're running through and make sure that the business is reflective of the actual money that's going through it. Can make a very significant difference, and essentially the difference between $100,000 or $3 million. So make sure you do that, and make sure you talk to your accountants in advance of when you are looking to sell. Really, we're talking about not preparing for a sale in a few weeks, but looking to sell in a few years' time and taking the opportunity to really forward plan that as much as you can, if you can. In terms of estate planning, another benefit of the Avant Law Group is that we have a really fantastic estate planning team that you get access to. And really, I think it's an underrated aspect of law and aspect of private practice that I'd really encourage everyone to take up the opportunity to make sure they have a valid and current will and enduring power of attorney. One thing that I have seen, and I've had this discussion with many, many clients over the years, is the old Australia Post will kit. Whilst it's better than nothing, it's only fractionally better than nothing as far as I'm concerned. And really you want to be talking to proper people that can actually set up and consider how you're going to set up your estate so that your family's really protected even after you pass away. If you don't have a will and enduring power of attorney, particularly a will, I really strongly recommend that you look to do that sooner rather than later. I can appreciate it gets put on the back burner, but it is a fundamentally important document to have in your life, because at the end of the day, you don't want your family to have even more stress and anxiety after you pass away and have to deal with the public trustee. So you've put in a lot of hard work over your career. Make sure you do the last 1% and get a really good will drawn up that outlines exactly how your assets are going to be dealt with after your death. Estate planning should also be an aspect of setting up your business. As I mentioned earlier, your shareholders agreement or unit holder agreement for your company or your trust should detail what happens when someone sells, particularly in a medical business. If your partner isn't a doctor as well and not doing the exact same specialty, it's not going to be much help for the other people in your group. If your partner comes into the business and steps in as a 25% shareholder director, because they're not going to be generating anything, and it's probably not fair that your estate receives 25% of everything coming out. So make sure that there's provision for a forced sale potentially if one of the shareholders or directors passes away. And that then interplays with your actual estate planning to make sure that if that does occur, potentially have the treatment of those monies dealt with as part of your estate planning, and really think about how you actually structure your assets whilst you're alive to make sure that you're not creating an inadvertent problem for your family after you pass away. We always say that you get back what you put in, particularly with wills and powers of attorney that are prepared properly. I've certainly seen my fair share of wills and estates being contested in the courts. And unfortunately, the only people that lose out on those ones are really your families. So take the time and do it properly. As part of it, you really need to think about how the assets are owned, particularly family trust and superannuation. It can be quite complex. So you need to make sure you think about that. Even how the property is owned. I know a lot of people might have joint tenancy arrangements or tenants in common arrangements, which is essentially a difference between if I pass away and my wife and I are tenants in common, then my interest won't automatically pass to her when I pass away. Whereas if we're joint tenants, my interest will automatically pass to her when I pass away. So thinking about how you own property is really important. And it even interplays with your estate planning. As you would expect, it's one of the most important things that people often forget about and don't think about, but it interplays with everything that you do in life. Testamentary trusts are a really cool way of dealing with assets after you pass away. Again, I said I'm a lawyer, I find really weird things interesting, but they're a really good way to deal with your estate after you pass away, to make sure that you're reducing as much of your potential tax exposure after you pass away as possible. And also potentially, if you're a bit worried about the kids doing things with your money, maybe it's a good way to try and look after them as another aspect even after you pass away. I've said pass away too many times, so I'm going to go to the next slide, but important to talk about all of these things with the right advisors. And as I say, I strongly recommend that you take up the opportunity to talk with our estates team, because I think it'll be beneficial for anyone listening in. Key takeaway, shocker that the lawyer's going to say it, but the document has to be in writing and really should be signed. There's a reason we harp on about it all the time, and it's because it can really be a massive savior for yourself. I don't mind if you do it once, you sign the documents and they go in a bottom drawer and you never look at them again. But the benefit is that if you do all of the agreements properly and get everything done right to start with, you can put it in the bottom drawer essentially and forget about it for the most time. And then if an issue ever does arise in the future, which hopefully it doesn't, you can go to that bottom drawer, and like an insurance policy, you can pull it out and refer to it, and it can save you a lot of time and money. Shareholder agreements in particular, if you are going into a group with other people, no one should go into business with people that they don't like. It's very rare for people to go into business with people they don't like, but unfortunately disputes do occur. If I had $1 for every practice I'd spoken to where they said we don't need one because we all get on really well, and then a few years down the track they're paying hundreds of thousands of dollars in legal fees to litigate an issue that they could have resolved for a few $1,000s with the proper agreement. It's a painful and bitter pill to swallow. So make sure you deal with it properly and get all those agreements that I've got up on the screen done and get them done early so that you don't have to worry about them later. It's a lot easier to review these things once they're done than to start from scratch. So it's an important aspect, and really they stem all the way through practice. So set it up properly, and the foundations that you lay really can make a massive benefit for yourself into the future. As I mentioned earlier, Stephen Schoninger, the employment partner, is doing a webinar tomorrow about navigating workplace complaints. I'm sure a lot of people, if they've been dealing in workplaces, which all of you have, particularly in hospital days and everything else, you will all have war stories about that doctor or that PHO or whatever it may be. And so really make sure that you have really solid employment agreements in place and policies, and don't try and do it alone, because you can have a lot of implications if you try and DIY it. You're not lawyers, you're all fantastic doctors, but we don't necessarily tell you how to perform a procedure on us, and really, surround yourself with the right people to help you out. We've got quite a broad offering, as I mentioned. A lot of people don't actually know we exist, so it's always nice to do a bit of a plug to let you know. It is commercial and corporate, wills and estates, property and employment, essentially everything other than family law, because we don't really want to be helping doctors have family disputes with other doctors. But if you have any other needs, we're more than happy to help. Certainly as well, surround yourself with the right advisors if you are looking to set up a private practice. We can put you in touch with excellent people for practice management, for governance, for privacy policies, all sorts of things that we've spoken about today. If we can't do it, we know the right people for you to talk to that are genuinely medical experts. So I'm always happy to have a discussion with anyone that may have some questions or some concerns. These are my details, so feel free to reach out and get in touch if you do have anything that is a burning desire. I genuinely mean it and offer it to people whenever I do these. I'd much rather have a half-hour conversation with you and at least try and point you in the right direction than have you go off and try and figure it out yourself. There's a lot of people out there professing to be experts, but they aren't necessarily experts. So I'm always happy to put anyone in touch or help you out along the way. I've got a few minutes for some questions, so I'll just have a quick look through. And certainly please do feel free to reach out, or if you're a bit shy and you don't want to put a question in the chat, feel free to send me an email or give me a call and we can talk it through. Yes, there is a revenue cutoff. So one question is, what is the revenue cutoff for payroll tax to apply? In Queensland, I think it's $1.3 million of a wage bill. It's important to know that that's wages. That's not the total revenue turnover for the practice. So if you've got a few nursing staff and potentially a few doctors, and you think you've got a relevant contract for payroll tax purposes, if the total money that you're paying to all of those people, i.e. wages plus the 70% that's going to the doctors, is over that threshold, then you potentially have a payroll tax liability for the money over that threshold, not up to. There's one question of been advised that payroll tax only applies when the business has a turnover above 6 million. It might be above 6 million if your operating costs are close to that $4-5 million mark, and the total money going is, as I say, over that 1.3. Does change slightly from state to state. So if you've got anyone from other states, just make sure you get in touch and I can give you the exact details. Rough benchmark for service fees for specialist practices. Look, it does depend on the type of specialist. If you've got a cardiac specialist, they might be able to charge more in the sort of like 50% mark, versus an anaesthetist who's got fairly low overheads might be sitting down around the 30% mark. So it really does change. Make sure you talk with your accountant. Your accountant will know exactly what the fair percentage is for your industry, because it has to be justifiable to the tax man. As a solo practitioner, you don't really need a contract with yourself. If you're an ABN doctor, sole practitioner that's just doing all of your own work. If you have your own practice as a corporate entity and you're engaging with your practice because you potentially might be employing your partner as your practice manager or something along those lines, you do need a service agreement. So there's an important differentiation between a solo practitioner that's just trading under an ABN and a solo practitioner who's engaging their own service entity. Just be mindful of that. Avant does have a privacy template that you can access, and I believe that you also can potentially get one from Practice Hub, who is wholly owned by Avant. Recommend you get in touch with them. They're very great at helping you run your businesses so that you don't have to worry about it. Yes, when you're selling, you do need to inform patients as a general premise that you are selling, but only your patients. So if you own the whole practice and you're a sole practitioner, you need to let them all know who to talk to. Probably a good one to have a bit of a discussion with as a sidebar to make sure that you're contacting the right people and letting them know where they should be going and how they should be going if you have any issues in the future. Good question of how do you notify patients if there's no local paper these days? I'd probably take the tact of whichever paper is easiest to put information out onto. It's a very old school provision, I accept, and it's very painful, but lawyers and government, unfortunately, are very old school these days. Avant Law does do every item that I've spoken about today. So if anyone has any interests about how they can use us or engage with us, please do. I say feel free to access these details and make an inquiry. Otherwise, if you scan the QR code, you can get onto our website and make an inquiry through there to speak with Stephen, the employment partner, Jennifer, the Wills and Estates partner, or Lindsay, the property partner. Feel free to reach out to them. Look, we aren't overly expensive. We've taken the opportunity to try and put ourselves in the market and be very fair. I can honestly say that we're not the most expensive law firm, but we're also not the cheapest. You get really good value, and we are all very experienced with the medical industry. So good question. Thank you for that one. Lets me do the shameless plug. If anyone, we've got one more. Are there any templates in Queensland for a tenancy agreement between a trust entity and a landlord for the landlord and practice operators if they are both the same? Probably need to be a bit mindful of having the same landlord and practice entity as part of your business. They probably shouldn't have rent paying within. Certainly if you own one in a trust as the property entity and your practice has a separate entity, you should have a lease in place. You can get some very simple leases, but they usually aren't commercial leases. I'd recommend you get in touch with Lindsay, our property partner, to help you out with documenting a proper arm's length lease between your practice and your business. A few more questions, sorry. Service fee for cosmetic units, where the fee provides for Botox, fillers, threads, consumables, which are quite expensive. Consumables are an excellent point. A lot of practices, particularly consumables and incentive payments, need to be very mindful of whether that's included as part of your service offering or if it's excluded, i.e. if you charge a 30% service fee, does that 30% include all of the consumables that the doctor may use in the practice? Or do you need to potentially charge the doctor or the patient for those consumables that are used in their consult in addition to the service fee? Just be very mindful that you have implications if you do split billing between the practice and the doctor if you are looking to recover those fees directly. But we can definitely look into that more if you'd like to. But yeah, important to consider and important to document within your actual service agreement when you do it. Last question, which is a very good question. I've been asked it many times over the last few weeks. Are all the processes required to avoid payroll tax worth the loss of control of your business? Ultimately, that's a matter for you. And I appreciate that's a very cop-out answer, but at the end of the day, you have to weigh up whether you want the control over these people. If you do want the control, do you look at employing those doctors? You have a lot of control under an employment arrangement, but at the same time, you then have leave, superannuation entitlements, and other things. that's potentially a bit of a risk for you. But if you're comfortable with the fact that at the end of the day, a service agreement really should be the doctors have the ultimate flexibility of when they work, how they work, and they're just engaging you to provide some services to them, then maybe it may be appropriate for you to keep the service agreement. It's really a matter, as I say, for each practice. Everyone is falling on a sliding scale where on the very far extremists, you have people that are making the doctors, tenant doctors, they're not providing any services to them. They're just charging a room hire fee, all the way through to people that are essentially employing the doctors, recovering all of the money, exerting a lot of control over them. So there is a genuine sliding scale of not much risk to a lot of risk, and where you fall on that, subject to the steps you implement, is really a matter for you. So always happy to talk about service agreements or any of the other inquiries that people may have. That's all for the questions. As I say, if anyone would like to talk about something specific for their practice, please do reach out. I'm genuinely happy to deal with any of these questions or these concerns offline as well, if you're a bit worried about putting it in the chat, as I say. But otherwise, thank you very much for your time tonight, and hopefully you all have a lovely evening, and we'll be in touch. Thank you.